greetings, greetings. It is I again, your King, Clifford Jefferson, reincarnation of King Edgar the Peaceful, which we know as Jesus Christ, the King of Peace. I also represent the House of Godfrey under the Godfrey, the fifth kind of band Jew, son of folk, ruler of Jerusalem. I have beside me my queen, representing the from the Galveston, who assisted me in the Battle of Hastings, going back to time immemorial, as well as Brother Archbishop, my Archbishop of the English Temple Church of England, from the House of Belmont, Judah, Archbishop Murphy from the House of Murphy, as well as our studious students paying their allegiance in regards to their birthright, which is based upon their political status, which is to protect their birthright and lose their allegiance to their king. I love you all. Thank you for your studiousness, for being here in regards to this joyous day, because it's on this day that we claim our estate. In regards to understanding our position as trustees in lieu of us exercising this authority and power that comes from the source, which is the grant of the king. On behalf of our exerted power that can be called at will in regards to willing to do ministering the estate on behalf of our beneficiaries whenever they come upon the scene. This is the reason why it's important to understand this information, to exercise this information, and protect this information. We are here again, like I said, with part 3, for understanding the difference between land banking and how it's funded by way of the legal tender or bills of credit, which were in violation of the laws that preceded the establishment of such a quasi-government. We know that the government is the authority figure that gives the authority and power, such as the charter via constitution, for those who limit encompasses the duties on behalf of who it restricts. And this is the colonists or settlers who were the ones who set up the plantations and enslaved the original inhabitants by way of the land banking system, which resulted by way of land banking offices that were established in all the so-called colonies, specifically New Jersey in 1723. At this time, we had what we call the loan office or the banking land bank established here in New Jersey as a result of what we call the authority of the King's Bench being transferred to Pennsylvania jurisdiction under the Supreme Court by way of the inherited equitable authority, which they don't have because no one can replace the King's Bench, because we know that all those are officers or inferior officers limited to their constitution. We know that all these judges who are sitting in that inferior offices are lawyers or attorneys or members of the bar. And we know that those membership within itself is a corporate entity established by or allowed to exist by way of law granted by the legislation. And we know that those who are part of the King's Bench are not called upon by active legislation, for they are the legislation. They are the ones who call upon the law and are there to protect the law in lieu of judicial review, which is established in the inner, middle, and outer temple. Inner temple means the information in regard to your vast history that goes back to time immemorial. Once that's understood, you move into the middle temple. The middle temple is the authoritative law that we use in lieu of substantiating our right to become trustees in lieu of administering the estate that were left intel by the grantor, which was usurped by those who are colonists who came here to steal your birthright by taking upon the English rights that was left by our ancestors in lieu of the treaties, laws, charters that were created, specifically the 1606 charter, which they as tenants-in-chief were supposed to be yielding on behalf of the assets that were here in the estate, such as gold, silver, etc. But it was not meant for them. But as a result of their usurpation of our laws and their breaking away from the established government that was here at that particular time, we now find ourselves in the position that we're in. So this is why this lesson is so important. I give my queen, Sister Godwinson, the second to say something, as well as Archbishop and CA, and then we can move on with this marvelous lesson. Queen.
Greetings. Just again, I want to give honor to the King in this marvelous lesson thus far. Some valuable information being brought to us today. Like I said, just take heed, pay attention, and you'll find yourself in a better predicament by, taking heed to these lessons.
Well said, Queen. Archbishop.
Greetings again, people from the Kingdom of England, Empire of Albion. Like the Queen Godwinson has said, you know, the king is given a profound lesson regarding our predicament here today, what we call within the Kingdom of England and the colonies. And the ship money, which is now known as legal tender, is what got us in this fiasco to get us usurped off our land, based off of what the king is showing from the land bank. So, and we all know, and we all seen land banks operating today within our territory. So the best way to understand what the king is explaining is only way for us to go back to who we were prior to them is we have to give them back all of their so-called funny money and take back the land the same way that they got it from us.
Mm-hmm. Well said. Well said. CA?
Thank you, Archbishop. Thank you, King. Thank you, King. Thank you, Queen. Thank you, everyone, from their respective houses. We're dealing with the modern day statutes and its applicable law as it relates to land ownership. The FHA is still in operation to this day. You yourselves may find yourselves in a state, and you may find yourself in a state of emergency. I trust everyone at the sound of my voice is gathering this information and doing their timeline as far as it relates to its origins and its applicability in modern day statutes. I yield the floor. Let's get back to this marvelous lesson. Peace and love.
Well said, counsel, as well as all those who are sitting before the council. We're glad you're here, as always, diligently and efficiently being studious as one should in regards to practical, applicable information that fits all narratives. There's so much that we can talk about, but it will be for naught, you know. So the only thing that we talk about is what's applicable and concrete in lieu of those areas or arenas that are more feasible for the results that we seek in regards to inherited equitable authority that derives from the authority of our ancestors, which are being established and being upheld and being supported in these courts of law. So I greet you here again for all those who are not on the King's bench, as well as those who are not here on the panel. I greet you in love, truth, peace, freedom, and justice. And as I say, and I always say, it's better for you to not know this than to know this and not follow it. Okay? We left off dealing with the municipalities and counties, which are called bureau villages, counties, bureau villages, cities, and municipalities. All exist within your counties, and your counties exist within your states. All these are the jurisdictions in lieu of this land banking system that functions today, where all the property is held in the day by way of what we call abstract deeds or straw deeds. All right, as we read here in New Jersey, it says that everything that filed in the county under Section 48 is only there for references and arrangement purposes, because everything must be recorded. There must be a record of it. But it has not sound in regards to it being legislatively authorized to be done. And this is where we find ourselves in as English heirs, that our state has not legislatively authorized the municipalities, the counties, the villages, the cities, etc., to overtake our estate in regards to the practice of fee and simple, which is by way of loan or mortgages that can never be paid back. As a result of that, as well as the property being totally insured based off what we call, not based off what we call an abstract title. Because an abstract title is a title that does not go back to the origin of the original owner. And the original owner of the title, i.e. the grant, was the grantor. And at that time, it was the king. Because you go back to any original constitution of the original colony, it doesn't say state. It says the monarch. And we know when we say monarch, we're talking about the kings who were sitting under the kingdom of Great Britain. It goes back to what we say Albion, which is time immemorial. Great Britain as the kingdom was established in 1707 by the unification of the Parliament of England, Ireland, and Scotland. These were ran by de facto monarchs under the parliaments under what we call the Commonwealth. We have incorporated as the English Stereotypical Church under the corporate name, the English Stereotypical Church of England, heirs and successors in regards to incorporating trustees pertaining to our religious society, so that the property that belongs to the English Church Church may transfer by way of conveyances in lieu of the original charter that we had going back to the Magna Carta, by way of conveyance of corporations, which means that the laws we had in the original religious society going back to time immemorial, we have now, through the certificate of incorporation, have incorporated those rights that existed back then through time immemorial. Now, to understand that, you must know what time immemorial means. And with these lessons, you will surely get there. So without further ado, we continue to go on with this lesson. So as we can see, in regards to land banking being funded by bills of credit or legal tender, which was unconstitutional, is not legislatively sound. Why? Because instead it's for the classification and arrangements in lieu of those records kept within the county. And the county itself do go back to time immemorial, those who know that. Back in our ancestors' days, they were called hundreds.
Mm-hmm.
Once again, they were called hundreds. All right. So now, why is my focal point relative to the territory known as New Jersey? Well, the middle colonies consist of Delaware, Pennsylvania, New York, and New Jersey, which is called the middle colonies. You got the northern colonies and you got the southern colonies. This money issue or currency act was created by the British monarchs on behalf of lawful money and the creation of this illegal money that was created by the colonists. And there was laws created so that this money that was created in Massachusetts, which is called New England, would not trickle down into those colonies that were being subject and were being or adhering to what was created by Acts of Parliament, i.e. the Currency Act of 1764. Okay, so as you're going to read, this is going to be an act by Edward Quentin Keesby, which was attorney from Salem, New Jersey. Let's just get a brief understanding who this guy was before we move forward. Anthony Quentin Keesby.
Which is the next town over.
Next time over. And great. Keesby, Perth Amboy. Next town over, y'all. All right. Please, can we get the paragraph?
Anthony Quentin Keesby, March 1st, 1824 through April the 4th, 1895, was a lawyer who served as United States Attorney for the District of New Jersey under 7 presidents. In addition, he authored a book on poetry called From the Hudson to the St. John's and Home Flowers, pressed in my law books. He was also a part of the writing of marching song of the First Arkansas. In addition, he wrote a law book called Slavery in New Jersey.
Okay. Name was once again Anthony Quentin Keesby, or Edward Quentin Keesby. All right. Now, why is this important? The guy studied at Harvard University. Now, Harvard University is one of the, or if not, the most constituent university in the United States. It actually was created from William's II's college, Queen's College. William, I don't want to be quoted, let me go to it, Harvard Law School.
Was it Harvard or Yale? Or you
Harvard.
For Yale?
Harvard.
Okay.
Harvard Law School is the law school of Harvard University in Cambridge, Massachusetts, New England, y'all. Founded in 1870. It is the oldest, y'all hear me? The oldest continuously operated law school in the United States and among the most prestigious in the world. It is frequently ranked among the top law schools in the country. Follow?
Follow.
Follow.
Here, history. Harvard Law School founded its trace to the establishment of law department at Harvard in 1817. Dating the founding to the year of the creation of law department makes Harvard Law School the oldest continuously operated law school in the United States. William and Mary Law School opened first in 1779, but it closed due to the American Civil War, reopening in 1920. The University of Maryland School of Law was chartered in 1816, but did not begin classes until 1824 and also closed during the Civil War. All right. So this is the law school that Edward Quentin Keesby went through. All right, he was a lawyer in New Jersey. Now, I want to go to an article from Harvard Law School written by Edward Keesby in regards to New Jersey and the big corporations.
Anthony Keesby.
Anthony Keesby. Because New Jersey is actually the origin where all these corporations got their start from in lieu of land bank. And y'all hear me? In lieu of land bank. All right. This article is so profound that we're going to have to read the whole thing. It's only 16 pages, but it's one of the best articles I ever read. And why it's so profound? Because it's from a lawyer. It's from an attorney in regards to what's going on here today in regards to the property being usurped by entities that don't even deserve a right to even be here, as established by Edward Quentin Keesby, Anthony Quentin Keesby. So let's go to it. Sister Walker, you can read. Now, this is a book from him. Hold it. I'll do it. The Courts of New Jersey from 1661 to 1912. That's the name at the bottom.
So it is Edward.
Edward Quentin Keesby. All right. Y'all pay close attention to this article. All right, let's rock. What's it, Sister Erica? You can start here. This is from Harvard Law School.
You muted, Sister Allen.
Harvard Law School, New Jersey, and the Great Corporation. Edward Quentin Keesby, 1891. All right, so this is from attorney in 1899. Harvard Law Review, as we read about Harvard Law Review. All right, now he's talking about New Jersey and the Great Corporation. Now, if y'all don't ever read anything from the King's Bench, you're gonna love this. Every nook and cranny of it. Let's rock.
New Jersey and the great corporations. With the increase of business prosperity, there has come within a few months past a very great increase in the number of large corporations. This increase has come not by the growth of old companies, but through the combination of small companies into large ones. In many of the leading industries of the country, manufacturers have abandoned the struggle of competition and have united their interests in a large corporation to which they have surrendered all their property and business to be operated under a common head and for a common purpose. The result of this has been an enormous aggregation of capital and the control of vast industries in the hands of a few organizations.
You hear this? Do y'all hear that? Do you hear the language coming from this attorney? He's supposed to be working with them. And I'm telling you, this is so profound. When we argue, we using this language. We cut and pasting what this man is saying about these land banking corporations. Because every time they get in trouble, what happens? They liquidate, they convert to that big corporation, which is running everything.
Yep.
Running everything. We shut down that one corporation, everything else falls. All right, let's go.
The large amount of the nominal capital, the great volume, and the extent of the business controlled under one management, and the rapid increase in the number of large combinations has caused alarm and aroused opposition among the people. And a strong demand is made that something shall be done by the states and the national government to restrict this power of combination and restore the benefit of free competition.
They talk about land banking. They ain't say nothing about municipality. It's at the federal and the state government. Something got to be done about these small corporations which got their authority from the big one. You can only start a small one from the big one. It can't work the other way around. So if a big one start one, of course, it's going to make smaller branches so it can extend its power, its resource, and still make money. That's called capitalization. This is the result of what we call feudalism, which, according to the statute, has been abolished. So Edward Quentin Keesby is saying that these people over here are still practicing feudalism. And this back in 1899. All right, go ahead.
Antitrust is all combinations for the purpose of diminishing the expense of operation and avoiding competition. And on the other hand, there is undefined but very real fear on the part of the people of the growing power of wealth and of the concentration of the control of great industries in a few hands. The suppression of small dealers, the control of the markets, and the consequent power to raise prices. This fear has expressed itself in legislation against trusts and combinations, and in many states, severe restrictions are placed upon all corporations that combine in any way for the purpose of avoiding competition, reducing production, or fixing the prices of commodities.
Okay, now this is an address delivered before the American Bar Association. And it said they're dealing with trust, combination. Let's get a definition. Make sure we know what we're talking about here. We don't want none to be ambiguous. Define. You mean no definition. A combination, we know what combination is. Trust in the combination in many states seriously restricted are placed upon all corporations. Now we know trust there with administration of assets, right? And if you got a trust which has assets, there must be an administrator of them. And we know that these are corporations ran by lawyers. All right, let's go a little further.
It is expressing itself more loudly in the utterances of political leaders and popular agitators, and more effectually in the decisions of the courts sustaining the validity of these statutes and declaring that combinations to prevent competition or to fix prices are illegal at common law as in restraint of trade. At the same time, and apparently, in spite of all these things, the tendency to concentration increases. And when agreements of combination among several corporations are declared illegal, they all turn their property over to a new corporation with enormous capital. And this, without restoring to any unlawful agreement, simply exercises the right of property. And by means of its vast wealth, controls the business more effectually than was ever done by means of the combination under the name of a trust.
Okay, so see how they bank out? Everything is based off the trust. And the trust is the action of the trust is extending it out to, and it draws interest on it. Because when they play trust, they're not talking about the Intel trust left for the beneficiaries. They're talking about the fiat they get based off the equity they grow from the mortgages that are assumed to be left in trusts for beneficiaries in fee and simple.
Exactly.
So that's how they make their money. And why is ran by attorneys. And because they mentioned trust. If you're dealing with a trust, you got to understand trust law. And if it involves trust law, you best believe there are some beneficiaries.
Exactly.
All right. And it ain't those corporations. See it?
point of interest, to even transfer title is a fee. So the county the county recorders are even implementing fees in the transfer of title, which not only exposes but shows feudalism or the practice thereof in its counties and municipalities.
Well said. I'm actually going down Tuesday. Me and my wife went down to get our certificates of incorporation filed on the county level, because we filed in the state by the Department of Treasury. So when I went down, they got me one all around. So I finally got to the right office, and they said I had to make an appointment. So my queen was listening to me, and the lady was saying that, well, why did I file with the state instead of the county? She said it's supposed to go all the way around. I said, well, where's the statute saying that? I said, all I'm asking you to do is authenticate the certificate of incorporation on the county level, because it's already done on the state. She said, well, she couldn't argue, she couldn't say anything.
Because
she put her foot in the mouth now, because she already she's saying that usually it's done the other way around. That you filed with the county, then you submit it to the state. I didn't go there because we just read that anything filed with the county is not legislatively constructive. So why would I do that?
Yep.
Indeed. And it'll also expose that their notaries have more power than their actual judges in their counties.
Yeah, it's the clerk that has the power.
Clerk
now, by virtue of the fact that the certification of the certificate of incorporation was filed on the state, and by me authenticated on the county level, and being that the county is not legislatively constructed, that makes our authority and power supersede theirs.
Exactly.
In regards to property, because your property don't even exist according to the statute, because under 48 6-1-6, it says you're not even legislatively constructed, but all your deeds is filed within the municipality and county. So how you got a right to anything? Because we know that's based off land banking. And we know the state can't help you out because the state don't even exist under the original agreement, which regard to us. And what was that used in that time was not no legal tender. It was gold and silver. So let's have our money.
Pound sterling.
All right, let's keep reading. So now when we're reading, remember we're talking about the corporations in lieu of private entities in a public forum exercising the right in regards to ownership of property. And when there's an argument brought on behalf of the right of the claimant in that property, they simply, by way of immunity, transfer that property over by consolidation or conversion of that all assets onto that bigger corporation. The judge, the lawyer just told on him, don't ask the king's bench, you go ask Edward Quentin Keesby. When we go to court, I call Edward B. Quentin Keesby to the stand. Call him right to the stand. You swear the whole truth, nothing but the truth, so help you God? Yes, I do. Excuse me, Your Honor, I'm gonna have to narrate for him because the cat got his tongue. And you just speak his word. I'm not lying.
Exactly.
You see that? We calling the dead to account for the record. Because it's on the record. This is a lawyer. He's a bar association from New Jersey. So if you're going to disqualify him, that means disqualify this whole courtroom because he supersedes you. All right, keep reading.
Remedies devised against combinations in the form of agreements and trusts seem to be inapplicable to the combinations that consist in the actual merger of existing corporations or in the formation of companies which merely exercise the common right of purchase of various properties and the goodwill of many business enterprises.
Wow, land banking.
And yet, although the legal form be different, the practical result of the transaction remains the same. There is the same aggregation of capital, the same combination of many individual enterprises under one control, the same avoiding of competition, and the same tendency toward what is commonly called monopoly.
Did y'all hear that?
Yep.
Did y'all hear that? This judge, this lawyer is saying that y'all got a monopoly going on and the citizens don't know what's up.
Yep.
He's telling me right there in his own words. This is a lawyer. Now, y'all lawyers sitting on this bench. Each and every one of y'all in this courtroom are officers of the court. Y'all went to the same school he went through, too. So why is he saying something contrary to what y'all supposed to be doing in this courtroom? That's my question. Hell with the subject matter. Let's deal with the law. Subject matter is irrelevant because the subject matter has always been irrelevant because of this damn law y'all practicing.
Point of interest.
Go ahead, CA.
When you think about your modern day criminal court cases and they say the judgment is on, a burden of proof is on the plaintiff.
Yeah.
In actuality, you're considered guilty or
they're proven innocent.
Or proven innocent. How do we know that's true? Because they'll arrest you and put a bond on you, which is an implementation of guilt, opposed to sending a summons or to a court appearance. Either way, it's a suit, but one is a criminal suit by a
one is civil.
Yeah, one is civil. So they're aggregating or attempting to capture the vessel, which that may be your physical essence and or your land or labor, and by capturing via your contract, social contract, is the subject matter jurisdiction. All right, I yield.
Well said. And this is a result, or this actually results in what we call the chilling effect. The chilling effect is a result of somebody telling you to do something that you know you got a right to do. You know what I'm saying? Every time you argue the subject, the law, instead of the subject matter, they trying to tell you to shut up. I'm not shutting up. How can I admit to the subject matter when the law is not even clear to me? You making a ruling off the law, not the subject matter. Exactly. Clear this law up and the subject matter will be irrelevant and will be my behalf. And that's our argument. Okay, let's continue.
The political and economic results are practically the same, and it is evident from the manifold expressions of popular opinion that the people well understand that the result is the same. The resistance to this tendency to the centralization of industrial enterprise will be continued, and new means will be sought for checking the tendency, even though it is working through the forms of existing law. The struggle between the two principles of individualism and cooperation will continue, and the question whether the best results are to be obtained by competition or by combination will be fought out until one prevails over the other or a new and composite result is obtained.
Okay, so the people have to understand that this is a political agenda, but that's not lawful agenda. It's just a political agenda, but not lawful. And the struggle between the individual and the cooperation will continue until the question comes up as the best result between the competition by way of combination will be fought out until one prevails over the other or a new composite result is obtained. We ain't asking them to fight over. We want a result by our endeavors. Our endeavors is automatically going to cause a result because your endeavors is just a sham. It's just a sham. All right, let's go. It's going to start getting good now.
This is a question of political economy, but at the bottom, it is the conflict between two social desires. And as Chief Justice Holmes of Massachusetts has lately said, the law is, after all, but the expression of the prevailing social desire in courts and lawyers. Therefore, we have to deal with these questions, and we must at least have some knowledge of what these desires are. And we must be familiar with the tendency of the statutes and decisions in which these desires are expressed.
You hear that? So this can't be abstract. It has to be concrete because the decision is made not on the streets. The decision is not made in the bidding pools. It's made in the courts of law. All right, go ahead.
I do not propose to attempt to discuss this difficult subject as a whole. It has been discussed in many pamphlets and textbooks and has been considered in various aspects in judicial decisions. And it will, no doubt, by the theme of many political speeches during the next few years.
Stop.
It has-
So stop. So this means that this matter has always or already been addressed.
Mhm.
Hell, we just see land banking system. It's a form of employment.
Yeah.
We see this is how they make their money off land banking system. So everything is connected. No matter if we play a part of it or not, it's still going to affect us because we're not even playing the game. We're not even in the game as
And
Black people.
and the name
That
of the
means
game.
that we only got one position to play. If we're never part of the game, that means we must have been the rule makers.
Exactly.
We're not players. Why? Because we made the rules.
Indeed.
All right,
Point
go ahead.
of
Go ahead,
interest.
Pierre.
Acquisition. Land banking is all based off of feudalized acquisition of lands by fraudulent conveyance of language done by the attorneys and barristers sitting in your municipalities and franchises de facto as quasi-sovereigns in transferring your intel and states over to fee simple.
Well said. Well said. CA. Anybody want to make a comment from the panel?
Point of interest, and like you said, this goes to show that everything that we're talking about, it has always have been here. What happens is it goes out of the consciousness of the people during that time, and they forget about it. But the corporations don't forget about it. That's how they move forward with their plans, just by you forgetting who you are. And so even with the land banks today, as they do their work, they don't think they're in their heirs out here because there's no heirs that have been presenting themselves to make a claim. But as you see, the statutes have been open and loose enough for that if an heir present themselves, that you can actually reclaim what is actually lawfully yours.
Mhm. They made them loose because they know that, oh, they so dead gone. We can put it right in their face. And they want to see it.
Well
You
said.
know,
Yeah.
but all these instituting of these statutes in regards to the common law of England have not been instituted or presented modern days.
Mhm.
All right, sister, who's this? Sister Alan, you can read now.
Okay. It has seemed to me, however, that it might be interesting to this association to hear some discussion of the policy adopted on this subject by the state that is commonly said to have done more than any other to enable this tendency to go on thus far under the forms of law. The state which first permitted the forbidden trusts to establish themselves under the form of corporations and has given legal existence to some of the greatest industrial and mercantile combinations of the country.
Read that again, please.
Okay, where did I go?
All right.
Right. Okay. The state which first permitted the forbidden trust to establish themselves under the form of corporations and has given legal existence to some of the greatest industrial and mercantile combinations of the country.
Now, right there
Mhm.
says it all. It says the state has omitted the forbidden trust. The state allowed them to do it, but the state ain't in on it. They said you can do it, but we turning a blind eye. We don't want to be held accountable because the legislative statute says it. You just there for reference and preferences. It's not legislative constructive because the state don't want you saying it up. The state said we can do it. The state did not say you can do it. It was a forbidden act that the state said, you know what? Even though we broke away from Great Britain, we must make a reconciliation between Great Britain, which we done through the statute. But the only way the reconciliation can be qualified is by the heirs. As long as the heirs don't step up in regard to the statute, y'all can keep doing what you want. But once they find it, you on your own.
You're on your own. Yep.
Oh, who was the one that said if they found out what you was that Thomas Jefferson that said
Thomas
they found
Jefferson.
That's Thomas Jefferson.
Yep.
yeah.
Any trickery.
On my
was-
birthday, it was called the ratification day,
Yep.
January 14th. He said, if they ever find out what we did, we in trouble.
And remember this right now, what's going on? This is right before, well, no, this is still around the time of Thomas Jefferson, but this was going on right before Thomas Jefferson. He just inherited what they were already doing.
Yes, yeah.
And they couldn't turn back. They was in too deep.
They was in too deep.
They complicit. And we just previously read how FDR in his New Deal tried to put the nail in the coffin people by taking your settlement certificates and aggregating those over to the corporation, taking away its what do you say, denying its nobility, if you will, or it's union with the crown. So you know, they've been putting layers and layers on this information to hide it from you, but it's been here the whole time. But you needed your king and the king's bench and the queen to decipher it. And it's an awesome journey, a magnificent lesson to all those.
Amen. Absolutely. Thank you. That's what I do. All right, continue on.
The trusts, having been declared illegal in New York as combinations and restraint of trade, transferred their property to corporations organized under the laws of New Jersey. And during the last 10 years, companies have been formed under the laws of that state, under which the properties and business of corporations in all parts of the country have been united under one management, with capital stock of many millions. And the combinations thus formed have accomplished all the purposes of those that have been declared illegal in New York.
Stop. So it said it was declared illegal in New York. So therefore, the law was passed in New Jersey. And it said not only New Jersey, but all the darn country. It says, it says, all parts of the country have been united under one management with capital stock of many millions, and the combinations thus formed have accomplished all the purpose of those that had been declared illegal in New York. So New York was declared illegal, so New Jersey took over and declared it good for everybody else. Basically. That's right. Let's go.
In the report of the Committee of the Senate in New York upon the investigation of trusts, there was cited as an example the fact that a combination owning factories in several states, including New York, but without any semblance of any interest in New Jersey, secured a charter there and assumed to carry on its business in New York, free from compliance with the beneficial restrictions of her laws.
You hear that? You hear that? So they just exercising dirty power they don't even have. As long as they comply with the Land Banking Act, they was good. Because they knew that it was all being funded off funny money.
And that's a point of mention. That's how most of these companies or corporations operate. They don't care about the legislation. They go according to the corporation who they work for's policies and procedures, as like that's the standing supreme law that they're supposed to be listening and following.
Yes. Exactly right.
I've heard in some cases the person representing them has lied and said, this is legislatively constructed. I've had somebody lie. Hey.
That's what they do. They put it in their face.
Yeah, you'd be surprised on what you hear them say, but once they know that you know, you may. I pushed them to the point of lie to me in my face. And she did. The lady lied in my face. So, yeah.
Well said. Let's go.
The fact that New Jersey permitted corporations to hold the stock of other corporations enabled any combination organized under the form of a trust to avoid the penalties imposed upon contracts and restraint of trade by simply causing a corporation to be formed in New Jersey and to purchase the stock and so control the property of business of all the companies concerned in the trust. And so it has come about that New Jersey destroyed the effect of the drastic measures taken elsewhere to stop the growth of great combinations of capital and the number and extent of Such combinations have increased until now, when the notorious Whiskey Trust, which has been attacked with every possible weapon of offense in many states, has lately been organized under the laws of New Jersey as a corporation with a capital stock of 125 millions, owning the property and business of nearly all the distilleries in the country. And the Federal Steel Company has formed under the same laws a consolidation of the steel and iron industries of the United States.
Stop about that. 1 second.
That's okay. And is the largest steel company in the world. A list of the largest industrial corporations formed within the past few months shows in a striking manner to what a very large extent New Jersey is responsible for the existence under the forms of law of great combinations of capital for controlling the industries of the country. 1,336 corporations were organized under the laws of New Jersey between the 1st of January and the 1st of August of the present year, with an authorized capital of over $2,000 million, and in a list of the existing industrial corporations having stock and bonds exceeding $10 million, 61 were organized in New Jersey as against 60 in all other states. The following are some of the largest companies of this charter organized under the laws of New Jersey during the current year. The Amalgamated Copper Company with a capital of 75 million. The American Woolen Company with a capital of 65 million. The American Hide and Leather Company with a capital of 75 million. The American Cycle Company, 80 million. The National Tube Company, 80 million. The American Steel and Wire Company, 70 million. The National Steel Company, 59 million. The American Smelting and Refining Company, 70 million. The United States Worst Company, 70 million. The Rubber Goods Manufacturing Company, 50 million. The American Ice Company, 60 million. The Distilling Company of America, 125 million. Federal Steel Company, 200 million. It is true that New Jersey is not the only state in which these large corporations have been formed. There are others which have offered great inducements to the formation of such companies. With West Virginia and Kentucky have for a long time afforded special facilities for the creation of companies intended to do business in other states, and Delaware has lately entered into active competition with the others.
Right there.
And that right there is our 30 minutes for part 3.
All right. Anybody tired?
Nope.